of the signer, a signature and its accompanying words is an endorsement unless the accompanying words, terms of the instrument, place of the signature, notice these things here, place of the signature, accompanying words, or other circumstances unambiguous indicate that the signature was made for the purpose other than an endorsement. For the purpose of determining whether the signature is made on an instrument, a figure affixed to the instrument is part of the instrument. In other words, an allonge. B, an endorsement means a person who makes an endorsement. And C, for the purpose of determining whether the transferee of the instrument is a holder, an endorsement that transfers a security interest in the instrument is effective as an unqualified endorsement of the instrument. And D, if an instrument is payable to a holder under the name that is not the name of the holder, endorsement may be made by the holder in the name stated in the instrument or in the holder's name or both. But signature in both names, get this, may be required by a person paying. You are the person paying the instrument. So you want to make it your requirement, not may be required because you're going to waive it then if you don't. No, I'm going to require because I'm the person paying. So again, the signature in both names may be required by a person paying or taking the instrument for value or collection. And that's what you're doing. You're taking their promissory note for collection, for payment. And you're going to require that person make the endorsement. And they're not negotiating it unless they do. And if they don't sign it or endorse it cleanly, then there is no foreclosure. Because the offer on the table is, produce the endorsement, and I will pay the instrument. Number 1, comments. Subsection A is the definition of endorsement. Endorsement is defined in terms of the purpose of the signature. If a blank or special endorsement, noted in blank endorsement, is made to give rights to a holder or transferee, the endorsement is made for the purpose of negotiating the instrument. Is your instrument made out in blank? In blank with the purpose of negotiating the instrument. On down further. Talks about this endorsement is also known as an anomalous endorsement. See section 3-205D, and is made for the purpose of incurring endorser's liability on the note. And in some cases, an endorsement may serve more than one purpose. It goes into some examples there. I'm going to jump down to comment 3, where it talks about subsection D. Because section 310A states that an instrument is payable to the person intended by a person signing as or in the name or on behalf of the issuer, even if that person is identified by name, that it is not the name of the person. In some cases, the name used in the instrument is in the spelling of the correct name, and in some cases, the two names may be entirely different. The payee may endorse in the name used in the instrument and in the payee's correct name, or in both. In each case, the endorsement is effective. But because an endorsement in a name is different from that used in the instrument may raise a question about its validity, an endorsement in a name that is not the correct name of the payee may raise problem of identifying the endorser. That's why you're going to ask for them to fill in the blank space with the name of the person who's going to cash the instrument. Continuing on, the accepted commercial practice is to endorse both names. Subsection D allows a person paying, that's you, or taking the instrument for value, or collection, that's you, you're taking it for collection, to require endorsement in both names. Now, 3-205. Special endorsement, blank endorsement, and anomalous endorsement. A, if an endorsement is made by the holder of an instrument, whether payable to an identified person or payable to bearer, in other words, it's in blank, and all your notes probably signed over in blank, and the endorsement identifies a person to whom it makes the instrument payable, it is a special endorsement. When specially endorsed, an instrument becomes payable to the identified person and may be negotiated only by the endorsement of that person. So I can't can't identify who Mr. Blank is, so you got to put your name in the blank so I can identify who's endorsing it. So the principles stated in Section 3-110 apply to special endorsements. We could jump over there, but maybe we won't. B, if an endorsement is made by the holder of an instrument that is not a special endorsement, it is a blank endorsement. And when endorsed in blank, an instrument becomes payable to bearer. In other words, anybody who's holding it can present and collect on it. Only if you don't ask them for identification. And identification being they got to prove the chain of purchases that gave them the right to have the instrument in order to negotiate it. So when an endorsement is blank, an instrument becomes payable to bearer and may be negotiated by transfer of possession or loan until specially endorsed. Get them to specially endorse it. And I've got a comment here myself. C3-204D may be required or it's waived by the person paying. That's you. Now C, the holder may convert a blank endorsement that consists only of a signature into a special endorsement by writing above the signature of the endorser words identifying the person to whom the instrument is made payable. And now D, anomalous endorsement means an endorsement made by a person who is not the holder of the instrument. You see, an in-blank endorsement is really an anomalous endorsement, proving that they are not the holder of the instrument. Let me read that again, D. 3-205D. An anomalous endorsement means an endorsement made by a person who is not the holder of the instrument. An anomalous endorsement does not affect the manner in which the instrument may be negotiated. But here's my caveat. But it does affect the status of the endorser as the standing with enforcement rights to foreclose. Because they must prove that they have the right to foreclose. And foreclose is not foreclose, you can take your property. No, it's really a presentment for you to collect, and you're cashing the instrument for them. They're doing banking. Official comments now. Number 1, subsection A. It states the test of a special endorsement to be whether the endorsement identifies a person to whom the instrument is payable. Section 310 states the rules for identifying the payee. In Section 3-205A incorporates the principles stated in Section 3-110 in identifying the endorsee. The language in 310 refers to language used by the issuer of the instrument. Comment 2. Subsection B now is based on subsection 2 of former section 3-204. An endorsement made by the holder is either a special or a blank endorsement. If the endorsement is made by a holder and is not a special endorsement, it is a blank endorsement. For example, the holder of an instrument, intending to make a special endorsement, writes the words, paid to the order of, quote unquote, without completing the endorsement by writing the name of the endorsee. The holder's signature appears under the quoted words. Endorsement is not a special endorsement because it does not identify a person to whom it makes the instrument payable. Since it is not a special endorsement, it is a blank endorsement, and the instrument is payable to bearer. The result is analogous to that of a check in which the name of a payee is left blank by the drawer. In that case, the check is payable to bearer. See the last paragraph of comment 2 to section 3-115, and that 3-115 is an incomplete instrument section. It basically says it is an incomplete instrument without the blank, without the bank special endorsement, which makes it payable to them. So a blank endorsement is usually the signature of the endorser on the back of the instrument without other words, in other words, without recourse. Subsection C is based on this section 3 of former section 3-204. A restrictive endorsement described in section 3-206 can be either a blank endorsement or a special endorsement. Let me give an example here. Paid to T in trust for B. So T will be the trustee and B will be the beneficiary. So to pay in trust, to pay T in trust for B. So here's our trust deposit, our special deposit. So it is also a special endorsement because it identifies T as the person to whom the instrument is payable for deposit only, followed by the signature of the payee of the check is a restrictive endorsement. It is also a blank endorsement because it does not identify the person to whom the instrument is payable. I'll put the caveat in here, until it's endorsed, then it becomes a special endorsement. Number 3 comment. The only effect of anomalous endorsement, defined in subsection D, is to make the signer liable on the instrument as an endorser. Such an endorsement is normally made by a accommodating party. See section 3-419. And that's going to evolve into suretyship. So 3-206 now, restrictive endorsement. And restrictive endorsement is going to limit payment by restriction. A, an endorsement limiting payment of a particular person or otherwise prohibiting further transfer or negotiation of the instrument is not effective to prevent further transfer or negotiation of the instrument. B, an endorsement stating a condition to the right of the endorsee to receive payment does not affect the right of the endorsee to enforce the instrument. A person paying the instrument or taking it for value or collection may disregard the condition. That's you. And the rights and liabilities of that person are not affected by whether the condition has been fulfilled. Now C, if the instrument bears an endorsement, 1, described in section 4-201B, or 2, in blank, or to a particular bank using the words for deposit, for collection, or other words indicating a purpose of having the instrument collected by a bank for the endorser or for a particular account, the following rules apply. Number 1, a person. Number 2 talks about a depository bank, which is the same thing. 1 and 2 say the same word just about. So a person other than a bank who purchases the instrument. In other words, the one who has a receipt for it's a stolen instrument. The purchase of the instrument, that's the one who has the receipt. That's the identification. That identifies who the owner is. A person other than a bank who purchases the instrument when so endorsed converts, that's conversion. Converts the instrument unless the amount paid, what is the amount paid? The purchase of the instrument. Unless the amount paid for the instrument is received by the endorser. So they must have had received the amount paid from the purchase of the instrument. That's the receipt. That's the ownership rights. The receipt. Now going to D. Except for an endorsement covered by section C, which we just read, if an instrument bears an endorsement using words to the effect that payment is to be made to the endorsee as agent or trustee or other fiduciary for the benefit of an endorser or other person, the following rules now apply. Number 1, unless there is a notice of breach of fiduciary duty. Now, that's nothing more than a breach of trust. Did you give a notice of breach of trust? Well, unless you do, there is no notice of a breach of fiduciary duty. No notice of breach of trust until you do. So unless there is a notice of a breach of fiduciary duty as provided in sections 3-307, a person who purchases the instrument from the endorsee or takes the instrument from the endorsee for collection or payment may pay the proceeds of payment or value given for the instrument to the endorsee without regard. That's without the proof of receipt of purchase now. We don't want to do that. So the proceeds of the payment or the value given for the instrument to the endorsee without regard to whether the endorsee violates a fiduciary duty or to the endorser read the last part through. Here should be two. Two, the subsequent transferee of the instrument or person who pays the instrument is neither given notice nor otherwise affected by the restriction in the endorsement unless the transferee or payer knows, in other words, has had notice, payer knows that the fiduciary dealt with the instrument, and that's by not endorsing the note, dealt with the instrument or its proceeds in breach of a trust or breach of fiduciary duty. And E, the presence of an instrument of an endorsement to which the section applies does not prevent a purchaser of the instrument from becoming a holder in due course of the instrument unless the purchaser is a conversion. Unless the purchaser is a converter under Section C or has notice or knowledge of a breach of fiduciary duty or a breach of trust, as stated in subsection D. That I'm going to skip. Official comments. Number 2, subsection A provides an endorsement that purports to limit further transfer or negotiation is ineffective to prevent further transfer or negotiation. If a payee endorses pay A if shipped goods comply with our contract, the right of A to enforce the instrument is not affected by the condition. In the case of a note, the obligation of the maker to pay A is not affected by the endorsement either. Comment 3, talking about, for example, suppose a check is payable to X who endorses in blank, but writes above the signature the words for deposit only. The check is stolen and is cashed at a grocery store by the thief. The grocery store endorses the check, deposits in a depository bank. The account of the grocery store is credited, the check is forwarded to the payor bank, and which pays the check. And under subsection C, the grocery store and the depository bank are converters of the check, because X did not receive the amount paid for the check. Payor bank and the intermediary bank in the collection process are not liable to X. The article does not displace the law of waiver, as it may apply to restrictive endorsements. You don't want to waive the rights by not knowing them. The circumstances under which a restriction endorsement may be waived by a person who is made is not determined by this article. Subsection D now talks about, under Official Comments 4, replaces subsection 4, former Section 3-206. Proposed payee endorses a check quote payable to T in trust for B. T endorses in blank and delivers it to A, the holder for value, or B, depository bank for collection, or C, payor bank for payment. In each case, the takers can safely pay C so long as they have no notice under Section 3-307 of any breach of fiduciary duties, a breach of trust that T may be committing. But giving notice is a breach of trust. Now there's 3-207, reacquisition, which is very interesting too. Reacquisition of an instrument occurs if a transfer to a former holder by negotiation or otherwise. A former holder who reacquires the instrument may cancel endorsements made after the reacquirer first became the holder of the instrument. If cancellation causes the instrument to be payable to the requirer or bearer, the requirer may negotiate the instrument. An endorser whose endorsement is canceled is discharged, and the discharge is effective against any subsequent holder. In the official comments, talking about the case number 1. In case number 2, X acquired ownership of the instrument after reacquisition, but X's title was clouded because the instrument, by its terms, was not payable to X. X can remedy the problem by obtaining Y's endorsement. And X may not be able to conveniently retain that endorsement, though. So Section 3-207 is a rule of convenience here, which relieves X of the burden of obtaining an endorsement that serves no substantive purpose. The effect of cancellation of any endorsement under 3-207 is to nullify it. Thus, a person's endorsement is canceled is relieved of the endorsement liability. Since cancellation is notice of discharge, discharge is effective even with respect to the rights of the holder in due course. So we'll go to, say, 3-419, and that is the instrument signed for accommodation party. And under C, it says a person signing an instrument is presumed to be an accommodation party, and there is notice that the instrument is signed for accommodation if the signature is an anomalous endorsement or is accompanied by words indicating that the signer is acting as surety or guarantor. An anomalous endorsement, though, what did we say an anomalous endorsement was? In blank. In blank. A person signing in blank, then, it is presumed to be an accommodation party. Now I'll read the comments further in that. But right after that, after 3-419 comes 3-420, which is conversion of the instrument. A, the law applicable to conversion of personal property applies to instruments as well as to real estate. So an instrument is also converted if it is taken by transfer other than a negotiation from a person not entitled to enforce the instrument. I'll read that again. An instrument is also converted if it is taken by transfer other than a negotiation from a person not entitled to enforce the instrument. We'll take out the commas in there. Take out the stuff in between. An instrument is also converted if it is taken by transfer from a person not entitled to enforce the instrument. What makes them not entitled to enforce the instrument? You don't come up with the identification, and the identification being the chain of title transfer that you purchased the instrument. You're not the owner. You're not the person entitled to enforce the instrument. Continue on. Or a bank makes or obtains payment with respect to the instrument for a person not entitled to enforce the instrument or receive payment. An action for conversion of an instrument may not be brought by one, the issuer or acceptor of an instrument, and two, the payee or endorser who did not receive delivery of the instrument either directly or through delivery to an agent or co-payee. In other words, get that delivery. You've got to have proof of delivery. D, a representative of a depository bank, say, attorney, who's representing the plaintiff, who has in good faith dealt with an instrument or is proceeds on behalf of one who was not the person entitled to enforce the instrument, is not liable in conversion to that person beyond the amount of any proceeds that it has not paid out. That doesn't mean they're not liable, though. How about aiding and abetting? Official comments in section 1 on the next page, though, is talking about section 3-420 states that an instrument is converted if it is taken by transfer other than negotiation from a person not entitled to enforce the instrument, or taken for collection or payment from a person not entitled to enforce the instrument or receive payment. This covers cases in which a depository or payer bank takes an instrument bearing a forged endorsement. So you got the right to ask for an endorsement. So that's an identification. Because that's really your intent. If you don't specify that, you're going to lose it. And they're going to put cards on you. Now, 3-605. 3-605 is discharge of secondary obligors, which is talking about suretyship, which has to do with 419, which is accommodating party. He talks about trust, because if a person entitled to enforce an instrument grants a principal obligor, grants, that's trust. Now the official comments under 3-605 says that, number one, that these rules essentially parallel modern interpretations of the law of suretyship and guarantee and apply when a secondary obligor is not a party to an instrument. Down farther it says that the resolution may be provided by the general law of suretyship because pursuant to section 1-103, that law is applicable unless displaced by provisions of this act. Number comment 2. Like the law of suretyship guarantee, Section 3-605 provides secondary obligors with defenses that are not available to other parties to instruments. And we're talking about parties could consummate transactions in 3 different ways. First, the borrower and the backer incurred those obligations with contracts not governed by this article. And in parentheses, such as note, as it is not an instrument for the purposes of this article, the general law of suretyship and guarantee would be applicable. And the second possibility is that the parties might decide to evidence, in other words, make a record, evidence the loan by a negotiable instrument. The backer becomes liable for the repayment obligation by signing the note as co-maker or endorser. In either case, the note is signed for accommodation. The backer is an accommodating party, and the borrower is an accommodated party. And the third possibility is that the borrower would use an instrument governed by this article to evidence its repayment obligation, but the banker's obligation would be to create some way other than by becoming party to the instrument. In that case, bankers' rights are determined by suretyship and guarantee law rather than by this article. See comment 3 to subsection 3-419. And then we go to 1-103. 1-103 is construction of UCC to promote its purposes and policies, applicability of supplemental principles of law. A. The UCC must be liberally construed and applied to promote its underlying purposes and policies, which are 1. To simplify, clarify, and modernize the law governing commercial transactions. 2. To permit the continued expansion of commercial practices to custom, usage, usage is trust, and agreement of the parties. That could also be a trust. 3. To make uniform the law among the various jurisdictions. Various jurisdictions. You can get out of a jurisdiction by claiming a law form, your type of tenure, your type of estate, by determining your status, your position. D. Unless displaced by particular provisions of the UCC, the principles of law and equity, there we go, trust, including law mentioned the law relative to capacity contract, principal agent, estoppel, fraud, misrepresentation, blah, 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 and all that. So, back to the courtroom, when they present to you your promissory note, and they ask you, is that your signature? Well, yeah, I think I would say that is my signature, because I'm validating that I am the bank. Are you now presenting this promissory note for collection today? Would you like me to pay it? I'll pay it. Your Honor, instruct the plaintiff to endorse the instrument, and I will take payment here and now. And have him provide an unqualified signature, along with the identification who proves who he is. What's going to happen? Is the attorney for the plaintiff going to endorse as accommodating party and accept liability? Is the plaintiff going to sign the instrument for payment? Are they going to both do conversion? Is the attorney going to do aiding and abetting? And do they have the proof of ownership, the documents necessary that they purchased the instrument and have the right to enforce it, which is the chain of titles, or else that's conversion. So if they don't sign it, or even if they do sign it, and they don't have the documentation to back up if they're owner and holder, then, Your Honor, I order you to arrest both of them today, now, because they're in conversion. Or, before even this even takes place, before you just entered into a mortgage case, I could take and come in and say, well, let's set this up for a hearing for the plaintiff to bring in the note for signing and again for proof of identification. And if they didn't, they might not even show up for the hearing. Then you can have your counterclaim in there and come at them for quiet title action and get the cloud taken off of your property. Get the mortgage off because you made an offer for payment and they never showed up. So why don't we open it up for questions now? Press star 6 on you. State your name, where you're from. Yes. What's this? Jacob. Hey, Jacob. Hey, John. Go ahead.
reading, I'll tell you. But what was the section that gives us the right to ask them to sign? Was that the 605?
No, I think that's like 203.
Let's see, 203. Got that right here, 204. The transfer of instrument, rights acquired by transfer?
Yes, it's in the official comments. It says the transferee's rights are derivative of the transferor's rights, whose rights must be proved. There's no presumption in 308 that transferee, by producing this instrument, is entitled to a payment. The instrument, by its terms, is not payable to a transferee, and the transferee must account for possession of the unendorsed instrument by proving the transaction through which the transferee acquired it, and proof of the transfer to the transferee by holder is proof that the transferee has acquired the rights of holder. And that's not exactly quite where I was thinking, but let's see. In the comments 1, the right to enforce an instrument and ownership of the instrument are two different concepts. Oh, excuse me, on the wrong one. 3-204 endorsement.
3-204.
Under D, it says may be required by the person paying. That's you. Or taking that. Now, in the official comments, it says under 3, talking about subsection D there, it says subsection D allows a person paying or taking the instrument for value or collection to require endorsement.
Okay. 3-204D.
Yeah, D, in the official comments.
Well, you can't get those online, right?
Yeah, but not the official comments, no.
I know, I'm on the regular one, but I was just saying there's no website that has the official comments online?
I don't know of any place online that does, no.
Okay. Thank you.
It seems to me there's another place that spells it out a little more better than that in the actual code, and I forget where that's at. 3-203 under C, unless otherwise agreed, if an instrument is transferred for value and the transferee does not become a holder because of lack of endorsement. It's talking about lack of endorsement under C, under 3-203.
Okay, I see that.
Then the last part says, but negotiation of the instrument does not occur until the endorsement is made. There we go.
But negotiation of the instrument does not occur until the endorsement is made.
Right. So in order for me to negotiate this transfer for collection, you must endorse it. If they don't endorse it, motion is dismissed. There's no collection, there's no way of foreclosing because, I made an offer for payment. And you guys are refusing to endorse it so I can pay it? There goes your case. Bye-bye.
CW?
Yeah.
How can we do this for somebody else?
For somebody else.
So in other words, if we have a family member that their house is, going into foreclosure, or they just stop paying for 1 month, can we just go in there and do this?
You might be able to maybe do most of the work paper-wise for them, call up a hearing, summon them into court for a hearing for the purpose of making payment on the instrument. And then, I don't know, we'll probably have to know what to ask for them in the hearing.
But couldn't they just grant an interest in the property? And then you have an interest in the property and you can do it yourself.
Yeah, but here's the thing. They may say, okay, what was your interest? How much is your interest?
It's not a minute
in here? Or do you have how much value they have put in there?
50%.
I don't know. Might have to go maybe 51%. I don't know.
What if you become a grantor, if they transfer the title to make you a grantor? Called grantor with 51%.
Yeah, well, we're talking about a statutory trust, and then I'm about to say the statutory laws, how that would apply.
I see.
Aren't you just, if you have any interest at all, aren't you you're a party in interest?
Well, we make defenses for, the plaintiff must have skin in the game. They can't just come up and say, well, I purchased this thing for, say, 10 cents on the dollar, now you got the right to foreclose on it. That was both ways. They could make a counter for that. Counter defense against that.
So if they quit claim the property to you?
Yeah, it's value. Well, was it for $10 and other valuable consideration? They may come up with a defense as counter, it's going to say, how much skin do you have on the table here? Or did you just do this to be able to come in and speak? They might not say anything. I'm just saying, thinking, they might. Because I know how these attorneys, they try to, every little thing they can do.
What if the party sells the property to a trust and you're the trustee of that trust?
If you sell it outright for full value, then there's no question. You got rights to enforce.
No, if they gifted it, if they gave it away to a trust.
Yeah, but then did you pay your other obligation before you gifted it, or did you gift it just to get out of paying the obligation? We've got statutory laws against that. You'll notify the trust.
So then, what method do we have?
Well, I didn't really come prepared to solve this problem. I came with a remedy that somebody can pick up and run with. So anybody else have a question? Here all along we thought we were being foreclosed on, and here we were actually doing banking in court, and we fell down on our banking knowledge because we didn't know anything about banking. Maybe we knew that we were banks and we were doing banking, but we didn't know how to do banking.
Christian, can I add a comment or maybe ask a question?
Yeah, go ahead, Chris.
Okay, let's just take a scenario. Say, for instance, you've got a copy of the promissory note. Well, if you were to go down and have it brought forward, re-sign it in front of the notary, and then you put your endorsement information on the back of it, you put it into UCC1, you do an assignment through the UCC3, give notifications to both the recorder's office and to the bank that you're requiring their signature on the back of it in order to cash it. This is without the court system and having to go that far.
So how am I acquiring the rights to their to sign for them?
Well, okay, so would you use something like an instruction letter that you're instructing them to endorse the back of it so it can be actually cashed? I mean, how would you go about doing it in the administrative side?
I think I might want to do it through the court. That way I can have more teeth that way and get a witness. And if they didn't come up in court, then I can get the court to certify my win. Now I got grounds for removing the fraud on the title, kicking the lien off.
But if you were to choose to do the administrative side, would it be by assignment through UCC3 via the UCC1?
Well, if I want to do it administratively, I could do a process on them and make them the offer to bring in, say, the notes, have everything set up, and see whether or not they bring in the notes. But
would you also... I'm sorry,
and break the witnesses that they didn't.
Which would be a breach of trust.
Okay, now, did I form a trust? Because really, I'm not talking so much trust right now. I'm talking more on a debt of credit or straight litigation stuff here.
Well, you think I propose it
I just right here now that I didn't see before under UCC, debt or creditor, that gave us a way out. Just under, say, doesn't really seem too much application trust-wise there.
Well, couldn't you send them some kind of like instruction letter they're talking about, or a notice that you want them to endorse the back of the promissory note, and when they don't do it, you could get a certificate of dishonor for that as a breach of trust?
Yeah, or to set up a place, public place to meet at such and such a time, such and such a date, and bring a note, and I'll pay the note.
Yeah. And do it like in front of a notary. Or maybe even like go under Rule 55 and go in front of a clerk of the judge, and not necessarily the judge, because she has the ability under Rule 55 to sign off on it.
What is it called when you meet in the library?
Could be in the court, but could have the clerk certify it. I think probably they would probably do it.
No, that's what I'm saying. It's just that, like, Rule 55,
with the stipulations in there that they have to bring, the identification, they're required to endorse, and they're going to endorse unrestrictedly.
Won't do that.
Great, then I can certify that the offer was on the table, that, I made an offer to pay the note, and now you won't come in? Then you're going to foreclose on me?
Well, it sounds real interesting, this information. I mean, it sounds like it's almost the silver bullet, the easy way of doing it, without going in, camera and all that stuff.
Yeah, possibly, yeah. Could come in with the conversion charges on them then. Conversion was under 3-206. D1 there. D1 and 2. And also 3-420. Conversion, you got the right to, if somebody, they're going to wind up being trying to negotiate a stolen instrument. That's criminal. It probably never would show up to the hearing, because it might get arrested.
What about cases where the grantor that signed onto a promissory note has a copy of the original promissory note they signed onto, and it doesn't match up to the same document that's filed at the county recorder's office, that someone had forged the signature on that document that's at the county recorder's office? And
let's say it's a fraudulent document that comes in with copies, the signatures don't match anyway, okay, that's fine. Bring in that and then get in there that they're going to certify that they're going to identify me in case somebody else comes back in later with the actual real note. They try to collect on this twice. But the point is, I think you're missing it all. You're not seeing it. If they sign or if they don't sign, I don't care, whatever it is, you can get them for conversion. Either way, because if they do sign, they better have the assignment trail, the identification to prove that they are the owners. If they don't, they're in conversion. If they don't sign, then they're in conversion anyway.
And they're going to want to settle out of court.
Yes. Either way, you got them on conversion charges.
If you've got a MERS number attached to a deed of trust, and that in itself is prima facie evidence that it's already been converted, is that correct or incorrect?
If it's already been converted, because you're saying it's been securitized, it's been a pool already?
Yes, it was. The document actually has a NIN and a MERS number attached to it before it was signed.
Well, see, then they probably can't produce the original documents that they need. They're going to be walking in with fraudulent copies. But the fact is they can foreclose on you is because you never said, okay, I'll pay the instrument. My gosh, if you say that, they're going to run out of the building, I think. Because they know they got to sign, and they won't sign. And if they don't sign, they know they're in conversion. They're getting the heck out of there.
It's certainly going to be interesting.
The thing is, if we address a letter to them and say all the above of what you just taught us, and basically tell them that if you don't do this, then you're in conversion or a crime and you can be arrested, should we just wait to say that and get them into court? Or, we can even say, if you can't provide and do what we requested, then this is our offer to you. You need to, because of you're guilty of conversion, you need to reimburse us or whatever the case may be of such and such amount of money.
Yeah, you could do that.
And this could be done.
settlement then, because if they are not going to do as required, they're foreclosing on you, which is what they're really doing is not foreclosing. They're doing a presentment of the instrument to you for payment. And you thought it was a foreclosure. No, you were doing banking. You were the bank, and they were presenting you, the bank, with the instrument for payment, for making a collection. They wanted it cashed. So now you can say, well, all right, I'll cash it. I mean, you just imagine the surprise on their face. All you got to do is endorse it. I'll cash it. And then prove the identity. Come up with the documentation that you got the chain of title. Just like it does do at the bank with you. When you take an instrument and cash it.
So a person looking at the new information that you're sharing with us would probably weigh this in as something more effective to nail them one way or the other rather than to use the Allonge information, right?
The Allonge information for
payment.
The Allonge information for payment. I'm not following, Chris. Hello? You there? You drop off?
Yeah.
His battery probably dead.
Maybe he'll get a different phone.
Yeah, he came on last night after a while.
Well, it seemed to me this would be a much simpler way of going, and then we give them an instruction letter and then say, if you don't do this, then you need to do this, otherwise we're taking you into court for fraud, collusion, and everything else. And you need to settle, conversion. You need to settle this within 7 days, or we're going to go ahead and ask, get you to prove everything in court.
Yeah, that's if we're doing it, but if your brother or your sister's in trouble, what do?
Well, do it for them and have them sign off on it.
And what happens if you end up having to go face to face?
Well, then what you do is you do a quiet title or a quit claim or a grant deed of where it shows that you're a party of interest to the documents, therefore you can stand in a courtroom.
You can do that with a grant deed?
Sure, it shows evidence that that person is a party of interest.
Yeah, but CW was just talking about that where, where's your interest? How much did you put forth,
It could be that they could come out with a counter to that because, you didn't really have skin in the game, so to speak. But they might not say anything. They might not even show up.
Yeah, I think if you gave them, because I imagine if you could get to the right people at the bank, to the legal department, and you could get into any kind of, correspondence with the proper party, then they probably would not show up. But if you didn't get to the bank and they just farmed out to, a mill foreclosure attorney, then those guys are pretty dumb.
You could create records that that's what you do either on a public venue or a totally private administrative remedy. If you got a certification, then you can take that certification and go after them just on the criminal charges.
Mm-hmm. So would you say a notarial presentment of a proposal like that would be in order?
Something to certify that you have put an offer on the table and have it certified that they didn't take it or they didn't do it, yes.
Yeah, good. That's a conclusion right there.
Christian, can you give any ideas for if I want to go and try to study for all of us to see how we could help other people where we can be a party of interest and not put anybody at risk?
Well, most of it is in 3-200 series.
Okay.
I'll talk about negotiation, transfer, endorsement. That's basically where the knowledge would come in right there.
Well, I think if we do a letter and put all the facts down in a letter and tell them that they need to prove all this stuff or else, and if they don't, then say, well, then you put forth the offer that they need to reimburse you or see, but they are. Because seeing as you're making a negotiation, there's no, when you go into court, yeah, but you're telling them they're not going to want to go into court. They're going to try and settle outside of it.
Well, you can always put that in your letter, though. That's what you're going to go for if they don't come up with the proper endorsement.
Well, the idea is that you get them way past the point of just a promissory note with the criminal charges, and then you tell them that you'll back off the criminal charges if they'll go ahead and give you the house, and you'll let them keep the note to save their own face.
With a payment.
Well, they pay off, they're off the account.
No, that's fine, but you can also ask for more. Why not?
You're going soft on them if you don't ask for triple damages. And so if you're not asking for triple damages, if you ask them for just like Eric said, a payment, then
too soft on them. Why not get them for the triple damages and the criminal charges? They both belong.
Yeah, why don't you?
Wow.
Okay, that sounds about right.
But they don't bring these stupid mortgage foreclosures on property that's already been paid.
That's right.
Well, I intercepted a communique from Fannie Mae to servicing agents that are handling MERS, chain of title servicing, that have become the servicers for Fannie Mae that's trying to swap up all these loans now. And on May 1st, they're going to change the way that they operate, I found out. And what they're going to do is the servicing agent is going to be made responsible for the chain of title to Fannie Mae. If Fannie Mae is now going to be the lender of record. And so now they're holding the servicing companies responsible for correcting the chain of title starting on May 1st.
That's only because they're losing too many cases in court for not handling it done.
That's right. I'll send that.
So it's like they're manhandling it to make it, when we find a remedy, they block it or obstruct it or create a new law that stops us from winning. I mean, it's so corrupt that it's so obvious that this is what they're doing. They're passing laws in order to help the criminals bust the chops of the American people.
Christian, did you think about how they could block this endorsement angle?
Haven't seen a way so far.
Okay. Well, you have to be, aware of.
They'd have to change the UCC code.
Yeah.
Which they probably will someday.
Well, I'm just wondering if we can just get in contact with, B of A and all these big mortgage companies to say, this is what's going on. If you don't settle on every account, then we are going to go ahead and bring you into court and show this information. I mean, basically, put them into a corner.
Is that confidential commercial information, though?
No, I wouldn't think so. Unless it's into your private trust.
So this seems much easier than going in camera because I saw a lot of problems there, especially with the protective order and everything else, in trying to get the judge to see all this stuff. We basically go this angle, and I think it's going to be a little bit more easier. And then watch it. Yeah, just get them into court and say, listen, I'll settle this. You just have to prove who you are and that you own it.
So you guys, if worst came to worst, the worst case scenario would be that we set all this up and our sister goes in there and we do a little, everything's already set up. All she's got to do is ask him to endorse the note.
Well, she could sign over that we're a power of attorney and then we can go in there and tell them what to do. Can't we do that?
Okay. we do that, Christian? Turning back?
Yeah, I've heard that being done in some places, yeah. But
you guys know Gary Jones?
So. Other than the person that really has the standing, it's kind of hard to pass on the knowledge because they try to get you for that, unlicensed practice or law or whatever. Not to say it's not doable.
Well, the thing is, are you power of attorney?
Hello?
Yeah. Why not get them to put your name on the mortgage?
Well, he said because if you show them that you have a qualified, interest, then they're going to say you did this as a scam, to do this.
Well, the new party in interest came along with an interest in the property as an aid to paying back the mortgage. That was the reason. Let them prove that it isn't. And now the interested party said, hang on, I smell a fish.
Yeah, because the interest party can basically say, I'll pay the whole thing, the mortgage. So right there, would that not be enough, Christian?
The interested parties without taking on somebody secondary?
Well, we're coming in just to pay the whole thing off. So we would be the interest party, would we not?
Somebody else?
Yeah, sign the debt over to someone else, or sign the mortgage over to someone else.
Well, I've used the assignment. When you reassign all the assets and liabilities over to another individual, basically it's a done deal. You get it notarized by 3 notaries. There's nothing they can do about it.
There you go.
Yeah, I say give it a try. I don't,
Go ahead and do that, Chris, okay?
I am.
Well, it sounds like it would work. I mean, it seems logical to me, and then we walk in there and we take over and we pay it off through our accounts.
We even have the FBI stand there and look at the papers at the county recorder's office. And they say, well, there's nothing we can do about it. The paperwork is in order.
Christian,
Yeah.
can you, there's a lot of work involved getting all that stuff together and getting to that point, and the actual date of the court event, if it came to having to become an event, couldn't we just, hire a regular attorney to walk in there with my sister for an hour?
probably could, yeah.
And then that way they can't do anything to anybody.
Right.
And you have a conference with the attorney telling them what they're there for.
Yeah, right. I don't think the attorney's going to do anything that you tell them, they'll tell you. That's the whole point, isn't it?
Around here you can get them to, you can talk to them.
Okay, cool. It's just whether they honor what you ask them to do.
Well, it kind of depends on what kind of attorney you get, because some of them are finally starting to catch on that their brothers here are also losing their homes.
You get a trust attorney.
It's colorable enough that they might not, be bending the court, so to speak, the rules.
Right.
The judge wouldn't say, look at it and frown upon it and say, well, you should be doing that, so it's colorable enough to probably bypass that.
You need to have just a guy walk in there just for a rent attorney?
Yeah, because and it's kind of, it's really going to twist the system and reveal too much truth. They're probably going to say, hey, Mr. Attorney, take the back door out, or roll over and play our game. But since this is strictly colorable, it's stuff that they're accustomed to seeing. It doesn't upset public policy.
Ah, okay.
So maybe an attorney might get away with it, and he might go ahead and do what you ask him.
Well, there's a couple of guys that are really on the mortgage thing, attorneys in California that I know of. And, they're so overburdened because there's so few of them. But if you could just get them and, point out the things that we went over tonight with them and said step in there for one session to oversee this endorsement thing if it comes down, and if it comes to where it actually has to go to court. Because it sounds to me, if you did it properly in a private administrative way, they'd be out of their minds to go to court.
I would think so. Who would show up?
That would be the last time the banks ever go to court.
The banks are because
Yeah.
I'd buy them and see what they have to say, see what they see in the flaws in it or whatever. They might make questions.
That's a good idea.
I think if you present it right, like Jacob said, they're going to settle right then and there. And you tell them, hey, you need to also cut a check for $500,000. Otherwise, somebody's going to jail because I'll take you into court.
What about if you got these retired judges or retired whoever they are, these arbitrators, and you got them to, take a look at this, like an arbitrator.
When you get into arbitration, that's a different breed of cat entirely.
Okay.
I wouldn't go into arbitration.
Yeah, because you have to go by their rules and everything else. So, I agree with you.
Yeah. No, I've been in arbitration, and it doesn't work out. Especially something like this. You'd be better off to do it the way Christian is saying to do it, because you've got the heavyweight here.
Any other questions? Anybody? Comments?
I did have a question on. I know what we put on the back. We were talking last night. For example, without recourse, paid to by special deposit and trustee and for the strawman and so forth. But I'm not quite sure what would you put on the front of a like a bill or whatever it is that you're receiving. I don't remember that.
You could just, depends on, I had like a form just like a check. You could put this on the front. There was the title of it was it's private non-negotiable special deposit order. And it's just like a check. It's got a number on it, number 1 or whatever your number is, and the date, and then the pay to order line, and that's the payee, the beneficiary. An example would be, say, your name. Then there's a dollar line. Below that, then there's the strawman account with Social Security number without the dashes. And the right is the signature line, just like a check.
Okay, I was thinking more along the lines of just taking the original bill, like a telephone bill or light bill or whatever it is that you get, and then turning that over and endorsing the back of it. But then what you do with the front, I don't know.
That's really an instrument coming at you on the 3-3-115, and they're just looking for your signature. So we give them our signature.
Can we turn it into a money order or no?
Well, not a money order, a private non-negotiable special deposit order.
That's right. It has to be private, non-negotiable, and it has to be special order because we're creating a trust in this instance.
But they pay to, say, ABC Bank in trust by special deposit for X, which is the same as in their example in the UCC. It says pay to T in trust for B, or pay to ABC in trust for X, or pay to ABC Bank and trust by special deposit for X, or any kind of combination.
Well, I like it. I like it because it's much more simple.
I'm beneficiary on the front and the signature line, and I turn it over and then endorse it on the back also, but I'm signing all three different positions. So really that's if I put on the back, P2 a blank spot there, then I can present it as a bearer instrument as payment to anybody. Because, you know, if I did my check and made out check to myself, signed the check, and then went to the bank, cashed my check, the girl's going to hand it back to me for endorsement. When I endorse it on the back, I'm going to sign it, and then she's going to give me, say, $100 for it. But if I signed it on the back, before I went to the bank, I could have met anybody on the street and said, hey, you know, I endorsed this over. This check is endorsed. It's cashable the way it is. They could give me $100.
But then the bank would look at that as a third-party check, and they don't honor those.
Unless you have an account there, you want to put it for deposit, then you would endorse it on the back, then the last person endorses always got liability. That person's standing good for the check if it turns out to be stolen or insufficient. But the thing was, I was all three parties signing on the thing, and I could have given it to somebody else just as money, the way it was. It was in bearer form. Same thing with this. Once you endorse it on the back and you signed all three, it's in bearer form. It's payment the way it is. Just give it to somebody. That's payment. As soon as you gave it to them, they were paid. Now you got problems, you know, where's this straw man account at, though?
Yeah, well, in my notes here, I have, that's what I put on the back, is paid to blank by special deposit. Oh. Now you say you put that on the front also?
That was a paid to order. On an example I gave you, I don't think I put an example on the front with a. But now you got a paid to order, the payee, the beneficiary, for example, where your name would go, and just like a check form.
Okay.
So that paid to line could be ABC Bank and Trust by Special Deposit.
Okay. All right. But that was the thing that I wasn't quite clear on as to what's put on the front of it, of the offer.
And that could be payment for X, wherever X would be.
The next time I get my phone bill, I'm going to try this.
Well, make sure you run it through your mind how this is working out, and think about, you know, what actually is happening.
Well, I'll probably be bothering you about it before I send it in anyway.
That's okay. Sure.
At least in that way, if I run through something real, I'll have a handle on it as to where I'm not thinking correctly, if I'm not thinking correctly in a certain area.
It really looks like nothing more than saying, a Federal Reserve note. Yeah, what we're doing is we're just passing it in circulation. It's really not being cashed by anybody. It's just we're passing one promise on to somebody else.
That's right, yeah. I know. It's just
nobody's cashing it, really.
Yeah. Just that they're not used to looking at it as cash, I guess.
Right.
You say, well, this is a new kind of cash that they're coming up with now that they're declaring that they are absolutely broke. This is the new Chinese yuan.
Question?
Yeah, go ahead.
I wanted to share something to see if this triggered anybody's creative juices here. But what it is it's a summary of what happens at post-closing of the securitizing of the promissory note. Because we're trying, of title, the chain of assignment, right?
Right.
So
That's the identification you need, yeah.
right?
That's the identification you need. That's what proves that they're the owner of the note.
Right.
As well as holder.
So this is a guy I'm working right now with to put together a securitization standing audit, and where you carefully examine all the documents, including and the mortgage and the endorsement, the allonge, the notice of default, and the pooling and servicing agreement to determine the identity of all parties involved in the chain of securitization and their respective interest in the note and mortgage. Once settlement occurs, the note and mortgage are normally transferred to a document custodian, example, Wells Fargo. While numerous book entries record their movement through the securitization chain, which normally begins with the originator, example, Beeson Mortgage, who then sells them to an aggregator, example, Countrywide Home Loans, who then sells them to 1,000 other loans to a depositor, example, Asset Securities Inc., who then deposits them with a trustee, example, Wells Fargo, for the benefit of the securitization trust. Example, Asset Securities Trust for 2003, 1234, 567890, which issues securities backed with a pool of mortgages, MBS. The trustee also selects a servicer, example, Countrywide Home Loans, to collect borrower payments and process foreclosures, short sales on behalf of the investors who own the MBS, pool of mortgages. When there is a default, and in order to effectuate foreclosure, the servicer asks the document custodian for the collateral file pursuant to the PSA should contain the original note endorsed by the originator, usually in blank, thereby converting it to a bearer instrument, and the mortgage and the deed of trust with an executed assignment either already recorded or in recordable form. Usually, this is where everything can fall apart, the secured party attempting to foreclose, and where the best defense opportunities may be uncovered by skilled onlookers. Below are some of the questions we ask when examining the file. And so, because along with this, I did some research, and I found out how we can actually get that evidence against them without even going through that. And so it's Form 2046, which is showing the original balance sheet, an IRS Form 1099 OID, which will identify who the principal funds originated from, which capital and interest was taken, and who the recipient of the funds is, and who is holding the account in escrow unadjusted. Form F3-A, registration, to show if, when, and where the promissory note was sold. The 424B-5 perspective, the security filing, the RC-S, RC-B call schedules, and FAS 125, 133, 145, and 95 forms are required. I wanted to share that maybe we can do some research and find out ourselves and nail them on the chain of the title along when we're asking them about to endorse the back of the note, to be careful that we already have proof of the chain of titles that they've already gotten criminal charges ready to be filed against them.
Yeah, I know about that, and we're using some of that. We put in a request for discovery, and we asked for the unbroken chain of transfer and deliveries from the originator to the trust, or current holder/assignee showing the ownership by the assignment, the title page, with an unbroken chain of transfer of delivery and acceptance receipts to document the transfer of the bearer note from the originator to the sponsor, along with the delivery and acceptance receipts with the bearer note from the sponsor to the depositor, along with the delivery and acceptance receipts from the depositor to the trust, along with the chain of transfers and delivery acceptance receipts from the originator to the trust and to the current holder assignee, and include also the names of the document custodian and anyone associated with the document transfer for the trust securitization foreclosure.
So with that, if we put that in as a notice when we ask for the endorsement with the legal department of the bank, try
to eliminate all the stuff that you said there, and we have to go ahead and work that ourselves. We just do discovery and make them work that for us.
Okay.
Information, they're toast dead in the water.
The discovery has to go into court.
Yeah. I don't know about you guys, but I don't mind working in court.
Yeah, not to throw court.
Well, my advice is, if you don't know what you're doing, stay out of court. Yeah, our tools, just like the Army Swiss knife, is really discovery.
Okay.
You know how to use it, and I don't have to do the work. Make them do the work for you. They're the ones bringing the claim. They're the ones that have to substantiate the NOI claim with the material facts, the SOIs. If they don't have the NOI and the SOIs, they don't have a case. They're supposed to have that stuff beginning at the original complaint, and if they didn't or don't, then they don't have a case.
Yeah, I don't know, I would rather just know somebody at the bank and have them give me this stuff.
Yeah, but they won't give it to you. You've got to either find out, because some of that is public knowledge.
Yeah.
Or you got to have them request them to bring it forward, and they're not going to do that.
I'll go ahead and do one of them, and then I'll report the results for you, and then you can tell me if it was, that hard. Because I'm just about ready to be able to do this on each loan. It just seems like the one part that you spoke about, talking about the front end, weren't you?
Talking about what?
We're talking about the front end. The stuff I was talking about is tracing, but you had a little bit of stuff that you were talking about that was about the front end.
Actually, on mortgage foreclosure, according to the rules, when they file the original complaint, they must have all the documentation required to prove standing, which is ownership and holder. They got to be their real party in interest. And in order to do that, they must have the originals in their possession, and they must generate copies off those and at least attach those copies to the original complaint. So upon my request of discovery, you should be able to produce these documents without question within the time allotted, without asking any extensions of time, because that's proven you don't have the documentation. And according to the rule, if the rules are saying like 1.130, that you must have attached all documentation to the thing to make the original complaint valid, and if you didn't have it, then the appropriate method for that is motion to dismiss. And go get the documentation, and if you're going to foreclose, refile the case.
And you're talking about as being the defendant, right?
Yes.
So if you're on the opposite end and you're the plaintiff in a non-judicial, is it the same thing?
In non-judicial, I'm going to bring an action against them and incorporate that into the case, and we're going to be in a case the same thing.
Okay. Just that you got to be on the offense.
Yeah, I'm going to put a preliminary injunction in on the thing and stop and freeze everything, or temporary restraining order until the matter is heard.
Hey, Christian.
Yeah, who's this?
This is Joe from Southern Nevada.
Hey, Joe. Go ahead.
I learned that a lot of these trustee companies that are foreclosing against people, they're supposed to, if they're like in California, they're supposed to have a power of attorney on file, recorded at the recorder's office, and they don't. Matter of fact, California Civil Code, Section 2933, it says, a power of attorney to execute a mortgage must be in writing. subscribed, acknowledged, or proved, certified, and recorded in the like manner as powers of attorney for grants of real property. That falls under agent principle, agency agent law.
And all those things should be at least copies of that attached to it, because one little document out of place leaves you room to chop the mortgage foreclosure off at the head. Well, really, they didn't have a valid process. They didn't have a valid claim. Now you could bring in actions against them for filing a frivolous claim in court. Or even if they didn't make the recording, or maybe they made a valid or false recording. I've got one case that they actually filed a false left pendant without that attached, and that makes it a false frivolous filing in a county record. Now you could come out with them with criminal charges for filing a false documentation. Because they have a power of attorney for the assignment, and they recorded a left pendant without it.
Exactly.
But they're cutting corners only because we don't know what to say and do and what to look for.
Mm-hmm.
And we're the ones that are allowing them to foreclose on us. We're our own worst enemies in court. We don't know what to say when we need to say it. We say too much stuff that doesn't pertain. We don't stick on point. We don't know when to object, what to object to. We don't know what we're looking for. I've seen a lot of people get toasted.
Christian, have you been in the court a lot yourself?
Well, I don't really go into court, but I've got a lot of court experience, let's put it that way.
Okay.
Well, I would say by filing a criminal complaint against them is certainly going to make them think, second, about going in there and beating you up in the courtroom. The other part I like about it is that when you accuse them of either false documentation or that they made a mistake, then it's the burden of proof is really on them, that they have to prove that everything is well. And so by just filing a complaint against them offsets a lot of you having to work really hard to protect your property.
Yeah, well, once you start taking a fire to their roof, you can't let up because you got to keep on pursuing, or else they look at it like, hey, you're going to drop the ball, and they'll keep on coming after you too.
Yeah, that's right. So for most of the people out here that claim that you announced this evening seems to be quite a winner because you got them left and right on the issue, and it's just a matter of very simple language that needs to be brought forth in the courtroom.
Well, anybody else? Question? Yeah, I have.
Well, let me read this off to you real quick. This is what I came up with based off of what you said yesterday and today. This is in regards to the endorsement. At the top, I put without recourse in bold uppercase letter. Below that, I put private, non-negotiable, special deposit. Third line would say paid to the order of great big fat line. Below that is by special deposit to with a great big fat line. Below that is by use of the exemption number. That's where the Social Security number goes in. And below that is lowercase Christopher Jamar Summers, trustee for uppercase Christopher J. Summers, strawman.
Is that for the back or the front?
That'd be for the back.
Back.
Does that sound like it's appropriate?
Yeah, without recourse on there?
Yeah, without recourse is at the very top, like you told me.
The one that was just very simple. Without recourse, first line, pay to, blank, second line. Third line, by trustee, your signature. And for the strawman account with the number without dashes.
Okay, so I can actually take the lowercase Christopher Jamar Summers, trustee for, I can take that out.
So that would be by trustee and your signature. That would actually be the endorsement line. And that's the Social Security number without the, that's the endorsement line. By trustee, your signature. Right. Don't, that line. Yeah. Below that is the next line down. For strawman account, Social Security number. No dashes. Oh. No data line. 4 lines. Yeah. Okay, second line. A2. That's all there. That's blank. Third line. By trustee. And your signature. No one. Last line. Or all caps name plus the Social Security account number without dashes. That's for the trust there. All caps name with Social Security number. Oh, okay.
Hello?
Yeah, Pete, go ahead.
Oh. Is Jacob in the group? Are we still on the private call?
No, it's not a private call. No.
This is the private call, okay. Eric's just asked a question. He's asking how this all ties in with UCC 9-210. I think it's 4A, but he's put A4. When they fail to endorse, is that another reason they fail to validate the death?
Okay, that's, what was it? 9-what?
9-.
210A4.
Yeah, 210, validation of debt.
Yes.
What was the question again that he asked?
When they fail to endorse, is that another reason?
Yeah, really. Because they're not standing for the validation of the thing. Really? Yeah.
Yeah.
I like it. Yeah.
So where are they endorsing? Where are we asking them to endorse?
They need to endorse the back of the instrument or put it on the launch or something. They need to endorse it someplace, last party.
So,
and then the clean signature, no qualifier, no without recourse, because if it's 910, everything's got to be clean here. There's got to be a liable party.
So we're signing the back of it, and now we're the liable party.
I'm asking them to endorse it. Just think like when you take a check to the bank. You hand it to them, and they flip it over, and they see where's the endorsement, or they give it back to you to endorse.
Yeah.
Okay. You're just like, you just got a presentment from them. You're the bank, you're the teller, and you're going to flip it over. There's no endorsement on it. You give it back to them, tell them to endorse it. Now let's see some identification, please.
Christian, shouldn't there be a clause in there, unrestricted? Shouldn't that be in there somewhere? Unrestricted.
Yeah, I would probably say, hey, you're going to have to endorse this unrestricted, yes.
So why are we writing on the back of it? Is that what we would write after they've endorsed?
No, I wouldn't put that on there. No, we're cashing the instrument. We're not using it, turning it into a bearer form, and then making a payment with it. We're going to cash it for them.
So where would the fund? Sorry.
When they sign it, now they become the liable party. But in order for them to endorse it, they must prove up the identification, and identification is they must have the proof of chain of titles that sets up the ownership right, not just holder. Just because they're holding and making a presentment does not mean that the instrument is not stolen. If they can't produce with a signature as well as the identification or the chain of titles, then arrest that guy because he's got a stolen instrument and trying to negotiate it.
In the event of a phone company or power company or something like that, when you do this and they send it back to you and say that this is whatever they're going to say, this is not valid or whatever they're going to say, and you're going to ask them for their endorsement, then or you're going to ask them for proof of ownership or whatever.
Yeah, but whatever. A mortgage situation, proof of ownership, chain of title. Okay, so that's securitized. It wasn't securitized. You got an account with them.
Yeah. Okay. All right.
But let's say that a traffic cop stops you in the street someplace and starts writing you a ticket. So you know what's happening? He just chose you out of somebody walking down the street, say, to you to be the one to sign his check that he's making up. That's going to make you liable for when he does a presentment to you for cashing it. Once you sign the instrument under duress, then they're going to take that and go into your account and cash it. But now you show up in court and ask them to produce the original. If the prosecutor may be in there, tell him he's got to make the presentment to you. And are you making a presentment here for collection today? Because I'm here to pay the instrument. Now, you've got to endorse it, Mr. Prosecutor. And if you don't endorse it, case dismissed. You refuse to pay because you haven't made an endorsement, and I can't pay until you endorse it. But he'll probably never endorse it because that makes him liable.
And then what if he refuses or he asks you why he has to do it?
Well, we're doing banking here. You got to put an endorsement on. I'll cash the instrument if you just endorse it. You want to endorse it? That's fine. How can you foreclose? How can you complete an arrest? How can you make a collection here? I'm making the offer to pay it. You got to endorse it.
I've got a blank one of the tax. Completely blank.
Say again, Pete, I didn't catch it.
I've got a blank check from the tax. I'm just wondering, should I offer them to endorse the thing? You know, draw them out into the public place, court, for example, and tell them to endorse it there. And then, should they fail to endorse it, then I can go and cash it.
In that case, you already got an account set up in there. You've already signed it prior to that, some other way. They're sending you a bill. So now that one, I might want to flip that one over and then put this endorsement on here without recourse. The pay to a blank fee for the account, and then give it back to them because now it's in bearer form. That makes the payment.
But it's blank. There's no tax value, no figure anyway.
There's no figure on the front?
No.
So what are they asking for, to pay something? There's no amount?
It doesn't say an amount what they're asking me to pay. It's just a remittance slip made out without a figure on.
Wow.
Isn't that just a zero balance statement?
No.
How much is due? How much is the bill for?
I don't know. You can't get an answer out of them every time that you try and speak to them. They never reply. It's as if they don't even exist.
I don't know if you have to do anything because there's no specified amount on there, so how much you owe. So I guess there's no obligation. Write back to them and say, well, 9-210A4 says, I'm going to make the assumption that the account is zero, and then within 14 days, if you don't respond with otherwise documentation to prove otherwise, this is satisfied.
Okay, thanks. Yeah, cool.
Christian, how do you apply it to a credit card?
When you get a bill, right?
Yeah, they send you an 8.5 by 11 piece of paper, and they got a coupon on the bottom.
Okay. The bottom would be like the front of the check. Put an endorsement on the back. Without recourse, paid to in blank by trustee, your signature for straw man, such and such, in that account.
And the private non-negotiable special deposit order on the front?
Yeah, I'll put that on the front, maybe, and then sign that. Yeah.
But if you wanted to terminate the credit card, you just send the debt validation letter, 14 days.
Well, I want to terminate, but I do want to keep the account, huh? Keep on paying. Well,
yeah. In some cases, I've got some family members that are over. They've got a lot of trouble in this area. I've got about 3 of them, and I told them I would try to help them. And so, they have like 5, 6, 7, 8, 9, 10 credit cards, and so maybe they want to get rid of 8 of them, I told them,
8 credit cards, I guess so, yeah. Get rid of a few of them.
I couldn't believe they have so many credit cards. So, to terminate, would you send them a debt validation letter and go that way?
Yeah, I would start out with the debt validation. If they didn't respond, then I got grounds to terminate, yeah. The key is put the debt validation in there that the amount is zero.
Right.
9-10 says, I got it right in front of me. Pay for it says request, but I would put demand. So, request regarding the statement of account needs a record authenticated by the debtor now, requesting that the recipient approve or correct a statement indicating what the debtor believes to be the aggregate amount of the unpaid obligation secured by the collateral as of a specified date, and reasonably identify the transaction or relationship that is the subject of the request. But approve. In other words, I'm going to put in there that the count is zero, and I'm going to get them to correct or approve that. If they don't respond back within the 14 days, then they agree that the count's zero.
That was 9-210. Is that what you're referring to?
Yes, A4,
A4, okay.
No question?
Yeah.
Is this call being recorded?
Yes,
Okay, then how could I get a copy of it?
Hopefully I can get the website up this week and get it up there.
My next question is, I'm curious to know which one of the old recordings, because I have some of them, that covers the claiming the asset and signing it on a UCC-3, going into detail. I don't have to be bugging everybody down in there. I could just listen to it and then do the filing from there. I'm going with also, of course, a sale by next week. I got the bank has.
I don't really know specific one, but I could send it to you to say it was all there. You know, there's quite a number of them. We go over the same thing over and over again, really. Off the top of my head, I don't remember which one. Is there anybody out there to point them in the right direction?
Yeah, if you listen from January on, will get everything he needs.
If you're struggling to get the recordings, then if you're on Skype or give me an email, then I can send you the document which has got some of the full shared sites on, and you can access the recordings from there.
Oh, okay. Then you have your something. I don't want to broadcast everybody's information on here.
Well, you add me on Skype, then it's Cheeky Monkey 1, CHIKIMONKI, and the number 1.
Eric is saying that he will have him Skype him for that information. I think this leads to good communication.
Right. I'm filling out the UCC-1, so I have a couple of questions about it. I was curious to know when it comes to the debtor is the bank. Is that correct? And then the secured party is me. I submitted. I give them valuable consideration.
Well, first of all, there's no debtor-creditor stuff on that form. If we're using it for a non-UCC filing as trust application, those terminologies change to grant or grantee.
Oh, because I did see the non-UCC filing aspect on the, I'm doing the online part, but I didn't know. Okay. So,
Eric wants to give his Skype name to you. Go to Imagine the One and make contact with him, and he'll share some information with you too.
thank you. But imagine the One.
That's with just a general number 1, not written out as 01.
IMAGINETHE and the number 1.
That's correct.
Very good. I appreciate that. All right, that's it. I won't go any further. I'll leave the call for someone else. Thank you.
Christian, on the front now, you would put special non-negotiable special deposit into the order of? On the front, private, non-negotiable special deposit order.
Yeah, okay. Okay, I got a question that I'd like to have you comment on for me. The other night, it was last night, that Chris had said for me to go and get I went down today, and what it is an application for non-repairable certificate is what it's called. And in the certification and signature, in bold letters, it says, let's see, the vehicle for which a non-repairable certificate is issued shall never be titled or registered for use on the highways, and such vehicle may only be used for parts. Now, I'm definitely not going to register it for use on the highway, but I'm not going to tear the car down and only use it for parts. So what if I take and black that last part out?
So don't they give you a salvage title?
That's what this is.
Yeah, well, you can drive on the highway. I did for years. Cars drive on the highway with salvage title. They don't care.
Well, according to this, they do. It says, I hereby certify and acknowledge that the vehicle described above is damaged to such an extent that it is non-repairable, and by so certifying, understand that in accordance with Section 46-1603-2 and so forth, Virginia Code, that the vehicle for which a non-repairable certificate is issued shall never be titled or registered for use on the highways, and such vehicle may only be used for parts.
I drove around I used to buy and sell those. They never used to care about it.
Are they asking you to sign under penalty of perjury?
No, they're just saying owner or corporate officer, authorized individual name, and then owner or corporate officer, authorized individual signature. They're not doing anything about penalty or signing under penalty of perjury.
Yeah, well, I wouldn't worry about it. I would do just what is being prescribed here. You can block that out. They'll take notice to that and they deny you. But the argument is that you're not signing that under penalty of perjury. Therefore, it's just hearsay what your agreement was with it. You scratch that off, and they may not like that. And there is a form. I'm going to look for you, but I think you've got the probably wrong form there.
Well, when I went in there and I asked for a junket form, she said, that's an application for non-repairable.
There could be your first mistake right there.
Well, if I go back down there and say I don't believe you gave me the right form, you have another form?
Just go on the web and find it.
Okay.
Is that the same as a total vehicle?
No. You don't want to register your vehicle anymore. You just want to put it up on block. It's called.
Oh, yeah, I used to get the total vehicle one. That's right. Different.
Yeah, that's just showing that it's a destroyed vehicle, and it's only to be used for parts. So he's got the wrong form.
Oh, okay. All right. Well, so then, what do I look for on the web?
Hey, give me a couple minutes. I'll see if I can find it.
Well, I didn't mean to take up everybody's time just for this.
Christian, are you there?
I'm here. Go ahead.
CW. A credit card, when the person fills out a credit application and then they create an account, that account is a trust account?
Well, they're thinking it's debtor credit, but I would turn it into a trust account, yeah.
Two different scenarios would be someone that has already done it versus someone that wants to get an account. Someone that's already done it that wants to terminate it, you would do a validation of debt, 14 days, and then set the account at 0, and when they default, have a certificate of dishonor, that you would use that as a trust res?
I'd use that as a colorable side that I could use in court in case anything happened and take me into court. But I'm going to say trust res being the application, that would be the trust res.
Oh, the application would be trust res?
Yeah.
So if I had a copy of the application and I returned that to them, would I be merging the titles?
No,
Like that.
special
If I did
deposit.
a one.
You have to come up with the records that.
Yeah, I do a 1 to 3 the records,
Right.
and then I return the credit application at the trust res to them. So I have to put a some kind of instruction in there that this is a trust and this is a trust res, and here's my.
Gilbert says that no person needs to know the trust is being formed. I don't have to have it. No.
But now I'm wanting to terminate that trust. So I'm gonna get my records in place, and I'm gonna return the trust res to them, and I'm gonna have to give them some kind of instruction. I'm gonna have to express the trust.
Well, I don't have to express the trust there because I'm really not in court. All I got to do is create the records now. I can create the records, terminate the trust. If I get any hassles, then I got to go into court. Then I got to prove trust. But I've already got the records created.
Do I have to prove the trust with the trust res?
Oh, not at that time.
So now
I got some kind of ability to prove it later on if I haven't got to.
you also have to take one of the coupon statements along as the trust res so that you have a balance on there that shows what the trust res is being merged with to zero out the account?
Oh, it's whatever the title is worth. The debt title is the asset title. So, what I'm merging. But let's back up a little bit here. Let's just say, when did actual trust res take place? I don't have to do the UCCs to prove the trust right now. I just maybe have to do it later on if I have to. The fact that an actual transfer of trust res property happened prior to any particular date. You see what I'm saying?
No.
The actual trust res forms when I transfer the trust res to the trustee. I just did a presentment to the guy who the trustee was, and they got it, and the notary certified that he got it. That's all I really need to start the whole thing. That forms a trust. Even though whether the notary didn't certify it at all, the trust res still was delivered to the trustee at a particular date. There was an actual transfer, even though maybe the notary didn't certify, even though it didn't do a UCC 1 or a 3. Does that stop the fact that the trust is a trust? No.
So the credit card company.
And now later on, 3 years later, I don't make my payments or something, and now this credit card company comes at me. Now I better create some records of what happened 3 years prior and have those records and then go into court, claim trust, prove trust. And by the way, what you do with my special deposit?
Okay, well, this particular thing has helped my dad. He'd have a heart attack going through that. So I have to be more careful.
But I better not have him do that.
Yeah, I would want to terminate it for him so there was no follow-up.
I think people are thinking that the UCC 1s and 3s, this is what forms a trust. That doesn't form a trust at all. It's when I actually transferred trust property in the hands of the trustee.
So is the credit card company the trustee and the beneficiary?
How are you setting the trust up? You're the grantor.
The credit app signature is the grantor, and the credit card company, I guess, is trustee and beneficiary.
So say that again. The last one. What? Who is trustee and beneficiary?
The credit card company.
Is trustee and beneficiary?
Yeah, because if I return the trust, if the grantor signed the credit app and created the trust res, on that day it was given to the credit card company, trustee and the beneficiary.
Well, what happens when anybody's got both ends of the title in one entity?
It terminates.
Yeah. You don't have trust.
Okay, so I see. So who is the trustee and who's the trustee then in that case? The bank is the beneficiary.
Are you talking about a
Chase credit card?
Me, I would make myself grantor and beneficiary, make the credit card company trustee. They got the application, they're trustee, the trust res was transferred, the application to the trustee, the bank.
Okay, so the credit card company, the bank, is the trustee.
Yeah, I'm beneficiary, I'm grantor.
So I transferred the trust res, the trustee, on the day that I signed the credit application and gave it to him.
Right, that's
now I'm going back and expressing that they actually have the trust res, or I have to give them trust res. They actually got it already.
Well, if they've already got it, have you said some way of creating records that you can prove that they got it? That way you can prove that the trust was formed because it was transferred.
Well, I'd have to have a copy of the application, wouldn't I?
Not necessarily. As long as you got a record that you transferred property to the trustee.
Okay, so I need a 3 to do that.
You need a 3 that you could put use a record.
And that will be the proof of the transfer of the trust res.
Well, that's just a notice.
A notice.
Yeah. Record. It's pointing to when the trust actually transferred and was formed.
And so now I just have to send them a copy of that record?
Yeah, I'll give them notice. Yep. I got you in court. Merge that, put in the records that you terminated.
And I have to, if I in court make them the beneficiaries and the titles automatically merge?
Not necessarily. In that particular instance, I don't have to, because what I could do is I could just transfer my right from me being beneficiary, transfer my title to the right, be in trustee, and that trust would terminate. I'm still beneficiary. So if they're going to wind up the trust because it's terminated, then what do they got to do?
Christian?
You got to disperse the funds. Who to? Beneficiary. Yeah, go ahead.
Hey, Christian, why can't you do this in one-page declaration when you first apply for the card and keep it on file and keep a copy or for the, if you do it in writing, that's what I'm trying to say. One page. Put all this and you have more proof and more evidence, can't you? Like we do on a land trust. One page.
For use later on in case you needed it?
Yes, and put it in file. I mean, why worry about it? You're going to use it later, why not do it now? You're going to do it, might as well put it in file. Or they have to be just the next.
You can create the evidence that you need right away if you want to, yeah.
I would do that. I do that on all properties that I have with my land trust. Very similar trustees and trust. Which I...
But I got lost when you disperse the funds to the beneficiary part. I'm the grantor beneficiary. The credit card company is the trustee, and I'm looking to get a record on a 3. And then
what happens when the titles merge in one entity?
Determinate.
Terminate. Okay. What has to be done upon termination of the trust?
What has to be done on termination of the trust?
Merge titles.
No.
That was terminated.
That's where any monies are paid out to the beneficiary.
Yeah, the trustee's got to do a disbursement of the trust. He's got to wind it up. He's got to liquidate it. And who's going to get the disbursement?
The beneficiary.
According to the denture, if the denture says that it's got to be given to the beneficiary, then it's got to be given to the beneficiary.
I don't understand what that equates to. If they make a disbursement to the beneficiary, which is me, and that the account has a liability obligation in it.
You as grantor made a special deposit into this trustee held in trust for for the beneficiary. Just like we talked about tonight. It was paid to ABC Bank in trust for beneficiary, B. So the bank is trustee holding for B, the beneficiary. The special deposit.
Okay, so my special deposit is my 3, correct?
No, your special deposit is the merging of the two titles or whatever the asset was that you put in there.
Credit app?
The res. Yeah, the res.
Credit app.
The corpus of the trust.
Corpus would be the credit app, right?
Yeah, that's the principal. The res, the thing. The application. That's the value. That's trust res property.
Okay. The UCC 3, which is the proof of transfer, when I do a notice, I have to do a public notice then?
Well, you need a public notice.
So, but I have to notice the trustee that there's I have to direct the trustee.
And you got to notify all parties. I was looking for something here, but I forgot what I was looking for, so I guess I won't look for it.
Was it something about the trust res or the corpus for the credit card thing?
Okay. I just remember what it was, the definition.
Okay.
Definition of special deposit.
Yeah.
Bank office handbook.
Which one?
Bank office and handbook.
Okay.
19.02. 19.02 C. Bank office and handbook. 1989. Special deposit may take on a number of forms. Sometimes there are means of holding funds in litigation, trust funds, and cash securities of various types. Cash securities. Isn't that what we're doing? Is when we're making out this instruments and all our names, and we put it in blank, that turns it into a security in bearer form. Cash securities of various types, such as deposits for good faith in the cases of contract and the like. Attorneys maintain such accounts to hold funds for clients for whom they are fiduciaries. Special deposits are created by special contract between the bank and the depositor. In most instances of special deposits for the benefit of a third person. That's just what we said. ABC Bank, paid to the order of ABC Bank, in trust for B, third person beneficiary. The bank becomes a trustee of the deposit for the benefit of the named person. Special deposits are often payable upon demand, sometimes upon terms, and occasionally very small amounts of interest. In many instances, such accounts are evidenced by certificates of deposit. Trust deposit now. Where money or property is deposited to be kept intact and not commingled with other funds or property of bank, and is to be returned in kind to the depositor or devoted to particular purpose or requirement of depositor or payment of particular debt or obligation of depositor, also called special deposit. Aren't you making a payment of particular debts, or you're making a devoted particular deposit to an obligation of the depositor? That's what a special deposit is. Trust deposit.
So is that going to be a trust receipt as well?
UCC 3 would be. But
Okay.
UCC security device not governed by Article 3 of the Code, consisting of blah, blah, blah. And today there must usually be a security agreement coupled with a filed financing statement. That's a trust receipt.
Okay. That's our trust receipt.
And equitable assets under an equitable trust. Lines 4. Equitable assets are all assets which are chargeable with a payment of debts or legacies in equity, and which do not fall under the description of legal assets. Those portions of a property which by the original or ordinary rule of law are exempt from debts, but which the testator, the grantor in other words, has voluntarily charged as assets, or which, being non-existent at law, have been created in equity. They are so called because they can be reached only by the aid and instrumentality of a court of equity, and and because their distribution is governed by a different rule from that which governs the distribution of legal assets.
Okay. So by keeping the claim and the transfer private, it would signify this is a private trust. If you have to go to court over an issue like this, then you would have to keep those as CC&I?
Yeah. Protective order for establishment of CCI, yeah. And here's some things to say, you might get problems because the judge, no. If you put the right elements in there necessary for a protective order, this guy did it. Got to grant it to you. But most people don't know what the elements are to put in for a protective order. But I'll put that in there.
But when the credit app goes to the bank, they're going to securitize that instrument. Is that correct?
Probably so, yeah.
Or they're going to create a bond off of it and securitize the bond?
They may put the bond in another pool, or maybe they might utilize the bond for themselves, or the proceeds from the bond if they're valid.
So they're going to have some kind of insurance that they've taken out on this account as well, aren't they?
Usually they have some kind of indemnification there, insurance-wise, some kind of insurance. Banks are very good at taking care of your property. All they do is they take a little bit off the top all the time, getting their cut. Or taking care of the assets for you. But
Okay.
They're all usually collecting interest. Usually the principal's still there. Held someplace.
So in the credit card trust, is there any instrument there that I can ask for back?
Yeah, the application and all proceeds generated therefrom. That trust runs principal property, along with all interest therefrom, all included with it, because all that's yours.
Right. Well, I'm trying to think of some kind of negotiating stance, as opposed to having to have some kind of enforcement.
In negotiating stances, the enforcement. You got to take them to court. When you got the fire on their building burning down, they're more apt to, say, give you back what you asked for. You might have to burn a few banks and stuff down first to get you what you want, but once we do that enough times, I think they're going to start falling in line and start becoming servants again.
Do they have to endorse that?
No, they'll put an order in to surrender the note, the application back. If they don't do that, now they have breach of trust. Now you go in the court of equity and get them for a breach of trust. And the burden of onus probandi, the burden of proof shifts now to the trustee as presumed to be guilty. And what does that do? Disbursement. That's all the court of equity wants to know.
But if you made a disbursement?
Yeah. And the disbursement would be, where was it at? Under the use there. Trust receipt.
The disbursement is the trust receipt?
The trust deposit. Return for payment of particular debts or obligations of deposit or devoted to a particular purpose. That's your special deposit, or your trust deposit.
Okay, the trust deposit is the special deposit, right?
Yes, they carry some synonymous. Same thing.
Yeah.
Trust deposit. Deposit.
Okay. And so that
be returned in kind to the depositor or devoted to a particular purpose. That purpose can be payment of particular debts or obligation of debtor, the depositor.
Real quick, Christian, will you tell that gentleman when he comes back on the line that my directions for him to go over to Law Learners the other night, he must have not done that because I went to confirm that set of salvage applications are over there waiting for him.
Mm-hmm. I tried. I got getting to the site, Chris, and I couldn't get on there and find that. I Googled. You're right. It's in the law.
take yourself off the registration with vehicles.
But I thought I had to go into your remedies in the law to do that.
No. Lawlearners.net.
Okay, lawlearners.net. Okay, that's where I screwed up.
Yeah.
Chris, have you done that with one of your cars?
No, I didn't have to because I terminated the agencies through an administrative default process.
Okay, guys, I'm getting late. I'm getting tired.
Okay, well, Bishop?
Yeah.
I just want to thank you very much. I am so impressed with your knowledge and your expertise, and just your recall of this stuff is so impressive. I do follow you very, very well, and I think I've got an endorsement for the back. I'm going to start working on the front, but it's impressive. I came up with one that's very streamlined. Thanks for spending the time to make sure I got all that information, and I think I do have it organized now where I can actually, I'll probably post it over there at the site.
Okay, great.
Yeah.
Thanks.
Yeah. Thank you.
Thank you, Christian. Thank you, Chris.
Yeah.
All right.
Good night, Christian. Good night, everyone.
Bye.